one judgment of the European Court of Human Rights related to the freedom of religion and in the gender perspective. So the fact that we didn't have a class last week and that we're having a feminist judgments course after this in human rights is actually turned out to be a very good thing, because now through this course you're going to have an overview of what the freedom of thought, conscience, and religion is as a right. And then we're going to have in the course after tomorrow, we're going to have a possibility to, after receiving this overarching knowledge, to look at one particular judgment. I'll tell you which judgment that is, and I will ask you to actually to go through that judgment and to reconsider it from the feminist perspective. So that will be the idea for the class on Thursday. And today is going to be, as I said, a sort of introduction into freedom of thought, conscience, and religion. So I will open the presentation.
How long will be the time for this?
Yes. Yeah. Thank you for your question. Yes, so the question is how the exam is organized. I will, I'll explain to you now, and then I'll also send you the exam instructions, so you can have it as well on, in the digital form. There are two questions at the exam. One, the exam is oral, so it's oral. The first question is, so to say, theoretical in nature, and you're gonna receive one question from a list of questions, which are related to the course and to the lectures. So one is, let's say, a theoretical one. The other is a practical one. So you're gonna receive facts of a case, and you will be placed in the position of a judge, of an international court. Let's imagine it's a European Court of Human Rights, or it's an international human rights committee. It's a UN human rights committee. So you will be in a position to actually render your judgment. So it's an oral presentation on the basis of those facts. You're expected to take a position whether, let's say, whether there has been a violation of the European Convention on Human Rights or not. And if yes, why? If not, why not? And also you can take a middle position that maybe with respect to one issue there is, and with respect to another issue there is no. So it's not so much about giving a right answer, because as you will see, as you could have seen, there are no always right answers. We are not sure about what the right answer is, but there should be a proper reasoning, a proper argumentation. And then when you start reasoning, then you inevitably come to an answer which is more, at least slightly more right than the other one. So it's about discussion, but you should be able to rely on the case law that we have referred to throughout this course.
And that's for the human rights.
That's for the human rights.
And for the feminist judgments, we will have to rewrite
the feminist judgments. So you will see that in her. Okay. So this is what I'm going to give you, and she's going to organize it in her way. For the feminist judgments, the course. This is the idea. I'm gonna have to. You will be in a position. I mean, this is how we have initially envisaged it. I don't know whether this year Ivana is gonna organize a different way, but normally it is like that, and we will do that kind of exercise as well after tomorrow, because we will rewrite one very famous judgment and controversial judgment of the European Court of Human Rights within the scope of freedom of thought, conscience, and religion. I will also introduce you into that topic, after tomorrow. So this is I will introduce you into that narrow topic, related to that case which you will have, to the background of that issue. And this, what we're going to have today, is a wider perspective, so that you can understand the weight of freedom of thought, conscience, and religion, and different dimensions of the freedom of thought, conscience, and religion. So it's a human right which is guaranteed by all international and regional covenants on human rights, starting from the Universal Declaration of Human Rights, and then European Convention on Human Rights, and then International Covenant on Civil and Political Rights. And it is actually one of the oldest internationally recognized human rights, freedom of thought, conscience, and religion, because it was religious identity used to be very, very important throughout the history, especially after in the ancient times as well, and then after the collapse of the Roman Empire, throughout the medieval ages. When we speak of the Central and Western Europe, the Catholic Church remained the only unifying entity for all those countries and all those monarchies and all those, and also Holy Roman Empire of the German nation, so of the German people. And also that the similar thing was the religion and the church on the side of the Eastern Europe and Southeastern Europe and nowadays Turkey, at that time Byzantine Empire, was also extremely important, because it was a state in which the monarchy and the religion were united. And then came the Ottoman Empire, in which, in the same way, Islam and previously the Byzantine Empire, it was the Orthodox Christian religion, and then came Ottoman Empire, in which also religion and the state were united. So that was the religious identity was extremely important throughout the history. And it started being internationally recognized in the 16th century due to the religious wars. And we mentioned one of the treaties, the Peace of Westphalia, which ended the 30 years religious war from 1680 to 1648. And even before that, there were the Augsburg's also peace treaty, in which it was already that time in 1555, it was recognized under the principle of cuius regio, eius religio, that religion was dependent on the region, cuius regio, eius religio. So those or we could say the religion follows the region. So if basically that was a formula which was used in order to find peace between, at that time, rivalry churches of the Roman Catholic Church and the Protestant churches. So the principle was that if the ruler was of one religion, Protestant or Catholic, then the region would also be of that religion. So we really have a long history of recognition of freedom of thought, conscience, and religion. When we speak of Europe, in Central and Eastern Europe, those countries which used to belong to the Soviet bloc after the Second World War, were heavily secularized. And so the religion lost the place which it previously held. But then, it looked with the with the collapse of the Berlin Wall, that all these ideological issues came to an end, and the famous American political scientist Francis Fukuyama wrote a book, The End of History and the Last Man, saying that basically, there are no more ideological debates. It's over. The liberal democracy has won the war, the Cold War. And then it's parallel to that, Samuel Huntington, another famous American political scientist, wrote the book Clashes of Civilization, and he drew attention to the fact that actually it's not really the end of the world. Like, cannot come to the last man, in the sense that, all these ideological debates which were very much present during the Cold War period, socialism versus capitalism, then socialist democracies versus liberal democracies, etc. That actually the things are not going to be as simple as that, and that we're going to live a period of clash of civilization. He wrote a book under that name, Clash of Civilizations. And we have witnessed actually exactly that clash of civilizations with attack on Twin Towers. I mean, like, basically due to the intervention of the Western civilization in the Middle East, but also a very tragic line of terrorist attacks which hit Europe as well in the first decade and the second decade of this century, with terrorist attacks first in Madrid and London in 2004 and 2005, and then again with the formation of the Islamic State at the territory of nowadays Iraq and Syria. There was a whole series of terrorist attacks, starting with attacks on Charlie Hebdo in Paris on the 7th of January 2015, and then in November 2015, other important cultural and sport sites and activities were hit in Paris, Bataclan, and other places in 2015 November, and then in 2016 Nice, and then in Berlin, in Manchester, London, etc., etc. So there's a long history of basically of revival of religions and revival of religious identities. And what we have to also understand, I mean, revival to the point of, as you could see, of physical extermination. And we could have seen in those places which were hit by those terrorist attacks, what it looked like to descend into natural state. Like there are social contract theories which explain the origins of the state and of the state authority, and they say that long time ago people lived in a natural state in which there was no. It was a natural state. There was no organized state. And that in that, sorry, it's not a natural state, state of nature. In that state of nature, basically there is no organized authority, and everyone is subjected to the power of those who are stronger. And it is for that reason that people decide to create a social contract and to establish between themselves a state, and then another social contract between themselves, people, and the government. So there is that very important theory to explain the origins of the state, and it presupposes the existence of this state of nature. Many other theories claim this is a bit illusionary, imaginary, because you cannot imagine what a state of nature is. But actually, when you find yourself in a place where there are these terrorist attacks, or let's say other places where there are still wars being waged, you can see what it looks like to be living in a sort of hell. So the religion religion is important, but religion can also be abused. And as just as any other value principle which can be abused. And it also is important to point out already at this stage, when we talk about gender equality, that I'll take the example of the United States. In 2009, there was a declaration which is called Manhattan Declaration, which was signed by something like 200 different churches and religious organizations in the United States. I mean, there is a big, how should I say, there is that, in that sense, a very, very developed diversity of religious identity in the United States. And no matter how these churches and religious organizations of different orientations, different origins, different traditions, etc., no matter how much they are different, and no matter how much they are in some parts of the world opposed in a way that they clash physically. For example, they found a consensus in the United States on the ground that the law, anti-discrimination law, should not apply to them. Yeah, they consider themselves to be that they should be exempted from the application of the anti-discrimination law. That they can discriminate. Well, they obviously they don't say that they can be discriminated, although if they think they can discriminate each other. So they can be discriminated in that sense. The point is to then you can go further with this, asking yourself what it means to have a right to discriminate. And basically, this is when you look closer into their demands. On one side, it's not so much about freedom, but it is also that freedom to be able to preach and to say what you think. So the anti-discrimination law does not limit you, whether it concerns your position as a religious church, as a religious organization or church, with respect to gender equality, with respect to sexual orientation or other issues. So that is fine to be able to preach. We will see now all the dimensions of the freedom of thought, conscience, and religion, but also to be able to discriminate within your own. So one is the preaching, the teaching towards the others, to advocate your religion in order to spread your thought, your mission. But on the other side, that you are allowed to discriminate within your own organization, so that the anti-discrimination law does not apply to you. Again, whether it comes to gender equality, sexual orientation, or other issues. So this is very interesting to see that kind of interconnection between the churches and religious organizations. No, they cannot. No. This was their position. Yes, this was their declaration. But you will see as we go along with the cases, I will draw your attention to the situations where I will mostly present you the case law of the European Court of Human Rights, and I will give you some examples of the cases where religion. Different religions and churches organize themselves in also making pressure on the European Court of Human Rights. And also you will find cases in which the American also different actors, such as churches, religious organizations, or institutes which are related to the churches or religious organizations, would also try to intervene in the cases before the European Court of Human Rights, fearing that the expansion of the case of the court on one side or another could have influence on them as well. So this is it's an interesting story which goes beyond the borders of the courts, of the legal issues, and the geography of European continent as well. So let's look at the text itself. The European Convention in Article 9, so this is paragraph 1 of Article 9, stipulates everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion or belief, and freedom, either alone or in community with others, and in public or private, to manifest his religion or belief in worship, teaching, practice, and observance. So this is the first paragraph. I will of Article 9. We will deconstruct it, but let's read immediately the second paragraph. Freedom to manifest one's religion or beliefs shall be subject only to such limitations as are prescribed by law and are necessary in a democratic society in the interests of public safety, for the protection of public order, health or morals, or for the protection of the rights and freedoms of others. So basically, paragraph 2 defines the conditions under which freedom to manifest one's religion or belief can be limited, whereas paragraph 1 says what the freedom, what the right is about, and you will see this distinction between the first and the second half of the sentence. Everyone has the right to freedom of thought, conscience, and religion. This includes freedom to change his religion or belief, and freedom, either alone or in community with others, and in public or private, to manifest his religion or belief. So there is right to, this right includes freedom to change. We will see that Article 18 of the International Covenant has a better formulation, but it suffices here to point out to the fact that this is considered as internal aspect. Basically, freedom to change presupposes that you previously had religion, certain religion, if you have a right to change it. And it obviously allows for the possibility to, if you didn't have it, to have it and then to change it. So a possibility to have a religion, to share, to believe in something, to change if you don't believe in it, but also it implies freedom to actually stop believing as well. So this is, you will see that formulation of Article 18 is a little bit better than this one in Article 9. So religion, belief, and so the religion or belief, we will explain these terms, religion or belief. This is very important. So this is internal aspect. And then there is external aspect. And freedom, either alone or in community with others, and in public or private, to manifest. Okay? So this is, it's not open from the, it's not totally clear from the language, but if you read the other international documents, it is, and it becomes very clear, and it's also very much clear in the case law of the European Court of Human Rights that the right to change religion, to have a religion, not to have a religion, and to change it is internal aspect of the right to freedom of thought, conscience, and religion. And there is external aspect, which is to manifest one's religion or belief. And now we have it more like exempli causa, exemplary situations, to worship, to teach, to practice, and to observe. We will explain all these concepts. So this is important because, as you could see from the paragraph 2, freedom to manifest one's religion or beliefs shall be subject to certain limitations, which means that internal aspect cannot be limited. So only the external aspect can be limited. Freedom to manifest shall be subject, and not the internal aspect. This is very much important because we may ask ourselves, what is the way to violate internal aspect, how it can be violated, and then how it can be protected, because it is something which cannot be limited. External aspect can be limited, and I will then just remind you of these conditions, but we will study them more into details. Only shall be subject only to such limitations as are prescribed by law. This is the principle of legality, and are necessary in democratic society. So this is what is called a standard of necessary democratic society, which is a separate standard that we will explain it as well. Very much important. And then the legitimate aims. So that limitation has to be provided by law. It has to be necessary in democratic society in every and each case, whether even if it is provided in law, in the concrete case, it may turn out that it is not necessary in the democratic society. And then it has to serve a legitimate aim. And that legitimate aim here can be public safety, protection of public order, health or morals, or protection of rights and freedoms of others. We usually distinguish between, when it comes to these legitimate aims, between those which protect society and those which protect individuals, although protection of society is also about protection of individuals and vice versa. So if you protect individuals, you protect the society. But these first legitimate aims are considered as being more collective, like public safety, protection of public order, health or morals, unlike protection of rights and freedoms of others, which is considered as individual protection of individuals. Did you have in the previous, in the other courses, did you come across to this test? The legality, necessary democratic society, and legitimate aim. Did you? Okay, you haven't come across it. Okay, good. Okay, we will then explain because we in the first class we talked about absolute and relative rights, and you have been mostly dealing so far with today and throughout this week we will be talking about relative rights. But with Professor Ivana Krstic and Professor Bojana Čučković, we've been talking about a right to life, a prohibition of torture, inhuman and degrading treatment, about prohibition of slavery, and these instances, these cases are cases of absolute rights. So, and these that we're going to be talking today and throughout this week are relative rights. So everything what we're going to be talking this week will be related to either religion, right, to freedom of thought, conscience, and religion, or right to private life, right to private and family life, or freedom of expression, or freedom of association, or right to free elections. Yes. Yes, exactly. It is inter partes because, and it is, you will see now the inter partes aspect. The absolute erga omnes.
Clear for me?
Yes. Yes. All human rights are relational, of course. I mean, human rights allow us to have relationship with others, so there is no doubt about that. Here, the concept of absolute and relative, the notion of absolute and relative are different. I mean, the terms are identical, but the meaning is different. Absolute means that those rights cannot be limited under any conditions. Okay? So, right to, ever since we prohibited death penalty, we introduced right to life as an absolute right. Of course, in the instances where there is a need to protect another life, the right to life can be legitimately limited, but then all set of standards have to be satisfied. In that sense, freedom of prohibition, sorry, not freedom, but prohibition of torture, inhuman and degrading treatment is also absolute, because you cannot torture anyone. I mean, you can physically, again, disable someone if respecting the principle of proportionality, if that is needed to prevent that person from attacking someone else. So, in order to protect a legitimate, equally or more legitimate value. But you cannot torture anyone under no conditions. You may torture anyone, even if you know that, like, you're 100% sure that that person knows about the bomb which is going to explode in some school full of children. Yeah. Like, and even if you think that the torturing of that person, and you have like email correspondence, and that person also admits that he is involved, so it's him or her. You cannot. Yes, there is no excuse. There is no condition under which you can torture anyone. These rights are relative in the sense that they can be limited. They're highest in the hierarchy of all individual rights in the legal system. They're human rights, so they're guaranteed by international documents. But by enjoying this right, you may actually violate someone else's right or freedom. So by preaching your religion, you may, for example, preach things which are contrary to the basic health rules of a civilized society. That is the inter partes, yes. Or, as you will see with the freedom of expression, freedom of expression extremely in hate speech. So freedom of expression is extremely important. I mean, one of the most valuable rights that we have. There is no progress anywhere in any discipline, in any domain, if there is no freedom of expression. But you can also, yes, for example, so you can start wars by using, excessively, by abusing freedom of expression, by not respecting the limits which are inherent to a civilized society. So this is why we have come to conclusion that these rights, this is the whole story about the advancement of women's rights, was to the detriment of the right to privacy. That right to privacy and what happens within the premises of one house, one apartment, cannot be, more important than, life, integrity, dignity of another person. So in that sense, things may come into conflict. And we will, this test is extremely important. It's, okay, I'll explain a little bit about the development of this test as well, because there is a history behind. You will see, because we will discuss more about freedom of expression in the class on Thursday, that a similar test exists with respect to freedom of expression, and the same is with other relative rights. So here we see that there are basic terms of thought, conscience, religion, and belief. These are the terms which are used here. You see, freedom of thought, conscience, and religion. This is also the title of the right of Article 9, freedom of thought, conscience, and religion. But then there is a belief as well. All of a sudden, this right includes freedom to change his religion or belief. So the question is, what is basically the difference between these concepts? Thought, conscious, and belief, because they come to one side, and religion comes to another side. So thought, conscious, and belief are relatively similar concepts. And European Court of Human Rights didn't really develop a kind of vocabulary, like a dictionary of what is he didn't have to go so far to say, what is belief, what is. There was no need for that. But what transpires from the court's case law is that we can group, that we can group thought, conscious, and belief on one side and religion on the other side. Yes. Yeah.
I'm curious, how can we not have thought or conscience? We have it because we are living human beings.
Yes.
We cannot turn it off.
Good.
So it's like natural to have it. Why do I need the...
Yes, why there is need to. Very good. Yes, very good. Okay, I will explain to you this. It's a very good question. Let's go to some sort of definition that we can find, and this is from the famous Campbell and Cossens versus United Kingdom judgment related to right to education. Article 2 of Protocol 1 to the Convention. And this was the case about corporal punishment of children in elementary school in the UK in those days. And so the Article 2 of Protocol 1 guarantees to the parents to have their children educated according to their conviction of the parents. And so the court entered into this distinction of these notions of Article 10, freedom of expression, and of Article 9, freedom of thought, conscience, and religion. So you will see all the how should I say, the whole variety of terms and the differences in the meanings. So the court says, in its ordinary meaning, the word convictions, taken on its own, is not synonymous with the words opinions and ideas, such as are utilized in Article 10 of the Convention. So opinions and ideas are one thing, and thought and conviction is another thing. Okay? Such as are utilized in Article 10 of the Convention, which guarantees freedom of expression. So that's Article 10, guarantees freedom of expression of of opinions and ideas. It is more akin to the term beliefs. In the French text, the term is used, conviction, appearing in Article 9, which guarantees freedom of thought, conscience, and religion, and denotes views that attain a certain level of cogency, seriousness, cohesion, and importance. Okay, so in other words, we have in Article 9 freedom of thought, conscience, and religion, and in Article 10 we have a freedom of expression. Freedom of expression is related to the opinions and ideas. And freedom of thought, conscience, and religion is related to the views that attain a certain level of cogency, seriousness, cohesion, and importance. Here, cogency, it means cogency is to have to be systematic, to be coherent, to be solid cogency, So opinions and ideas are derived from random, superficial opinions and ideas, views that you may have about something, up to very developed ideas about things related to the society, for example, the political life, about how the education should be organized, how the economy should work, etc., etc. So the freedom of opinions and ideas can be very. It's a broader term. It can be something very superficial, or it can be something relatively important or very important. But here we refer to the views that attain a certain level of cogency, seriousness, cohesion, and importance. Basically, this is a secular definition of what religion is, and a system of beliefs which give you answers to the fundamental questions of life. And they are, as you can see from another very important judgment, which is Kokkinakis versus Greece. The court said in that judgment, freedom of thought, conscience, and religion is one of the foundations of a democratic society within the meaning of the convention. It is in its religious dimension, so now we speak only about the religion, one of the most vital elements that go to make up the identity of believers and their conception of life. But it is also a precious asset for atheists, agnostics, skeptics, and the unconcerned. The pluralism indissociable from a democratic society, which has been dearly won over the centuries, depends on it. So, religion is, but not just religion, freedom of thought, conscience, and religion, all these belief and conviction, all these different terms denote views which are of such a cogency, seriousness, cohesion, that they make part of the identity of each of us. It may be a similar identity or it may be a different identity. You may believe in something like be a religious person, but you may also be, as the court says, atheist, agnostic, skeptic, and the unconcerned. You don't have to be protected under Article 9. It can be some sort of secular version of religion. Like, for example, some people have very strong feelings about pacifism. Like they take it almost as a sort of religion. So the freedom of thought, conscience, and religion protects some views that have, once again, as the court says, urgency, seriousness, cohesion, and importance, which are of such a kind that they make part of your identity. You can't dissociate. You cannot see yourself taking gun and, let's say, start killing someone, because this is what pacifism is about. And you want also to preach, to teach that others should also, give up guns and start living in peace. Or, as I said, as the history proves, this right particularly concerns religious people, because religious identity has been very, very, very important and is still very much important across the world. And people cannot simply imagine themselves without their religion. The religion that they were born in, that they were brought up in, that they were taught in the schools, in their families, etc., etc. So that's for many people that's so much important that it deserves particular protection. But it may have, let's say, its secular version that we can more imagine than find particular case law in the court, in the court's jurisprudence, simply because the court was, in most of the times, confronted with the religion, not the secular religion issues, or with freedom of expression issues, which, as I said, range from very banal cases and situations to very developed, like ideologies. So protection of ideological views and ideological considerations would be under Article 10. And under Article 9, it's for sure religion, or maybe some if you prove a very strong commitment towards a secular, some secular, comparable secular issue or secular system of beliefs. And we saw actually an evolution of the court's case law in that respect with regards to right to conscientious objection, for example, exactly not to serve the arms. And the court recognized the existence of the right to conscientious objection. Although Article 4 allows actually because it explicitly says that serving army will not be considered as a form of slavery. So serving army is considered as legal systems may have obligatory army. Now more and more they're introducing it, obligatory army service. And the court initially considered that conscientious objection would not be considered as a valid argument not to serve the army, but later on it took into account the freedom of thought, conscience, and religion, and then it accepted, for example, the conscientious objection in a case.
Prove that it's like offensive.
Yes.
And that it's like.
Yes. That person proved its commitment by Atiana versus Armenia. Proved simply that that he had such a strong commitment, such a strong feeling about it, and that's going to be also interesting in the context of the family judgment case that you will see that I'm going to give you. So this is about the basic terms. Let's look at the way the International Covenant on Civil and Political Rights is drafted. Everyone shall have the right to freedom of thought, conscience, and religion. This right shall include freedom to have or to adopt a religion or belief of his choice. So here you have to have and to adopt, which means to also, if you don't have to adopt it, and then to change it. No one shall be subject to coercion, which would impair his freedom of to have or to adopt a religion or belief of his choice. Now here you see exactly what it may look like to have how you can that there is a need that one should take into account that the International Covenant on Civil and Political Rights was drafted after the European Convention on Human Rights. So they took into account maybe that the formula in the convention was not perfect, and that you should explicitly protect, because it is implicitly protected, like an absolute right which cannot be limited. Here it is explicitly protected as an absolute right. So this internal aspect is absolute, because no one shall be subject to coercion which would impair his freedom to have or to adopt a religion or belief of his choice. So maybe do you have an idea how one can be forced to have or adopt a religion or belief of his choice? But it has to be a more systematic one, not just during what? Yeah.
The religion or coercion.
Yeah, that's a very good example of dervish system where you had to change religion in order to, and you were actually children were taken, what is called blood, taxing blood, children were forced to leave their families and take the other Islamic religion. In more modern terms, I mean, there is no certainly an optic reader of thoughts. I mean, that as far as I know, that has not yet been devised.
Right now, it's more free to obtain
Yeah.
the religion. There is there is stigma for obtaining from that religion and religion tradition.
Yeah.
But not in the coercion towards that.
Yes.
Or,
what about, for example, mandatory classes, religious classes for children of young age? There are countries in which they are. If you have mandatory classes for children of young age, could that be considered as a coercion?
Well, yeah.
Yeah. Or maybe in those countries in which Marxism was an obligatory course, because it's a philosophy. So you can, like some philosophies you can associate to religion.
Well, yeah, but also the because of the secularism.
Yes.
Having flowers and religious traditions.
That was about manifestation. Yeah, that will come to that point.
Yeah.
That's a manifestation. Here I'm speaking of situations in which you're systematically exposed, so that, let's say, brainwashing as a bit extreme or maybe inappropriate, but very very illustrative example of that kind of coercion, brainwashing, where you're constantly brainwashed.
Maybe on the public religious.
Yeah, but that you can say, you can always change the channel.
If
you don't have to watch it, you can turn back.
Your family is really religious and you don't feel that way, and you are put in religious school and various like.
Yeah, there are different ways, and we will be. This is all relevant for our case study, and you will see from the case law which I'm offering you here some other examples. But before that, just to take a look at this is interesting. On the basis of this Article 18, and actually on the basis of every article of the International Covenant, the committee has issued, the Committee on United Nations Committee on Human Rights has issued the commentary, the general commentary, which looks a little bit like some kind of legislation and a kind of textbook. It's very interesting. You will see that they actually define certain concepts. So it says the general commentary number 22 on Article 18, it says the freedom to have or to adopt a religion or belief necessarily entails the freedom to choose a religion or belief, including the right to replace one's current religion or belief with another, or to adopt atheistic views, as well as the right to retain one's religion or belief. Okay, we have talked about Article 18, paragraph 2. So that is the absolute, the internal part. Bars, so forbids coercion that would impair the right to have or adopt a religion or belief, including the use of threat or physical force, such as the Vishnu system, or penal sanctions to compel believers, or the Inquisition and other kind of tortures inflicted upon people to change, to admit something, penal sanctions to compel believers or non-believers to adhere to their religious beliefs and congregations, to recant to reject their religion or belief, or to convert. policies or practices having the same intention or effect, such as, for example, those restricting access to education, medical care, employment of the rights guaranteed by Article 25 and other provisions of the Covenant, are similarly inconsistent with Article 18, paragraph 2. The same protection is enjoyed by holders of all beliefs of a non-religious nature.
So we have this in Afghanistan,
Mm-hmm.
because we have the use of force and terror action.
Mm-hmm. We do.
Yeah.
Mm-hmm. It is definitely. Yes. When you are when you're forced to wear a religious piece of clothing, but when you're forced to wear it, you can imagine that that kind of forcing affects that kind of external manifestation that you do not accept willingly, but you're forced to do it. Affects actually one's internal perspective, so internal dimension. That after a while you simply, maybe you will deep inside yourself, maybe you will develop even a stronger resistance, or you will just subject yourself to it.
Yeah, right now it's going even beyond just wearing the religious clothing. I think that I have read that they're making them wear eye patch.
Yeah.
Which is say that for women, not one eye. It's only so it's like going beyond just religion.
Yes. Yes. Or mesh over both eyes, but which still allow you to see, but you know, the women to see, but you cannot see their eyes. It is. I think it is very. It's limiting personality of that person. It's prevents that person from expressing itself.
Yeah, it's the main fear. They cannot.
Sorry?
It pushes them back to privacy if they cannot go outside without some clothing.
Yes.
Then
it's true. It's true. I will.
Can I just ask something?
Sure.
I can't really hear the. Yes. I will maybe also put on my camera so you can.
Yes.
I can't really listen, hear very well the colleagues. I hope that I'm not repeating anyone. But isn't it the same as here in Serbia? For example, me myself, I was baptized when I was a kid, and I had no chance to actually have a choice or to choose a religion or not to have a religion or any other choice. So, and now I have also a choice to maybe be, I don't know how to call it in English, but dismissed from the Orthodox Church. There is no procedure for me to say I don't want to be a part of this anymore. So I think it is really also connected to the examples we mentioned.
Yeah, this is why this internal aspect allows you to change it, in the sense that it is limited to your internal dimension. So to your let's say in a very illustrative way, to the person's head and what that person feels, considers. The whole point about guaranteeing this right, the internal aspect of freedom of thought, conscience, and religion, is not just that you should not be cursed to accept something, but that you should also have the possibility to to come in contact with other religions or beliefs and convictions, and maybe to understand that you don't want any religion, you don't want to be a part of any religion, or that you want to change that religion. But this is very interesting that what you have mentioned, Una, because obviously, for example, you don't have to say, state anything, but one may come to the conclusion that you feel that the mere fact that you were baptized and that you are registered somewhere in some book, some official register, that you are a part of the Orthodox religion, of the Orthodox Church, that you feel obliged by it in a way, that it concerns you, although you can just ignore it and you can say to yourself, well, this is not me, it was someone else who did it, contrary to my will. And the legal system allows me to change it, to believe in something else. So here it is said clearly to recant, to reject, that internal aspect includes right to recant, to reject that religion. But this is very good. Good. It shows, because you will see some other example cases from the European Court of Human Rights case law, which are similar or maybe even more aggressive way of affecting one's internal aspect. Yeah. Thank you, Una, for your intervention. So, for example, this case, Buscarini and others versus San Marino, it was a case where the members of parliament of San Marino at that time were obliged to take the oath on the Bible. So because the religion and the state are not. It is San Marino was not at the time, and even still San Marino, the name itself, contains the elements of religion. So the state is not totally secular, and so they had to take the oath, invoking the Bible and putting their hand on the Bible. And they said, this is contrary to our conviction, so we don't want to do that. We don't feel comfortable doing something like that. Another interesting case is, for example, Dalab versus Switzerland. It will be important for our further analysis of in the context of family judgments. And Dalab versus Switzerland was about a school teacher who was wearing headscarf. So she was wearing a headscarf, and Swiss authorities consider that by simply wearing a headscarf, and she was in elementary school, working with very, very young children, like maybe even 5, 6, 7 years, and that she was that the mere fact that she was wearing a headscarf was making an impression on children. And that position, that fact would have consequences on their psyche. In the sense of seeing this as a role model, and that maybe that would be violating the freedom of thought, conscience, and religion of children. Of children, yes, because this is yes. They were very, it's interesting. We will have discussion in 2 days. And then another interesting case is Lauzzi and others versus Italy. I don't know, maybe you have heard about it. It's about the presence of a religious crosses in the Italian schools. And in that case, one family brought the application before the European Court of Human Rights, claiming that, among other things, parents claim that their right to have their children educated according to their conviction was violated because they were not part of the Catholic Church, and it was a public school, and they had to see crosses in the schools, and they considered it as a sort of oppression on their children. So that's an interesting, also an interesting case. And for example, in that context, you can ask yourself. For example, in Serbia, we have in the schools, in the classrooms, we have yes, the sort of replicas of a fresco of Saint Sava, who was our archbishop in the 12th century, at the turn of the 12th and 13th century. And he was the founder of the Serbian Orthodox Church. So he was an archbishop. But at the same time, he was also considered as the founder of the school. So there is that kind of a double hat that he has. He was, and
he is also full Slava.
Yeah.
Slava is religious.
Yes, exactly. There is that part. Yes, there is that part of that something that is typical for our for the Serbs, that in the Serbian Orthodox Church, that every family has its saint patron, and that every family who wishes, who chooses it, to have its saint patron, and so it looks like it's okay for the families, individuals, to have these kind of things, to celebrate in particular one patron, the saint patron, like Saint Nicholas or Saint Athanasius, for example. But we have also a kind of a weird practice of some institutions having also saint patron. So that's an interesting case. I will maybe say a few things about Dalab and Lautsi when we come to the to what is called proportionality test. But there is Bayacan versus Armenia. I mentioned it's about the conscientious objection. So there are other things interesting to explain, and I will. What do you say? We don't make a break and then we finish a bit early, no? Is it fine, or do you want to have a? If you need to have a break, yeah, we can have for 5 minutes. Okay. Okay, let's say then for 5 minutes and we'll continue.
Možda da uzem da radim opet kuće, pa da se namontiram, pa da dođem ovdje ono štikle, dopučnik, sve, da radim nešto tako namontiram i onda da palim na možda. A kao ovo mi neću malo to. Da sam ti to? Ma da ne bi. Da mogu. Prvo popiš. Znači, hajde, piši.
Naša Margarita?
A?
Margarita je bila ovdje.
Da. Da, mogu bi ne vidiš. Piše mi super da operem masku. Pa mi je krista rekli za kaj, i to već tako štukam, i uđe kućaka, i uđe u kući. Nema sad, uđe da.
Mislim da ne pjevam. Neka prima, nešto. Ali glavu, da bi cijelo kosa štrili. Onako, znači da opet staviti. Ne da pometi to.
Ne skupila zdravo.
Najbolje, dobro.
Da. And they with caffeine is all electrically doesn't get okay, but it's called helpful and more stronger than and then it's like the opposite of this, and basically week for a weekend in there. I don't have weekend things yet, so it's okay. The parents shock crunchy. So time sleep. Yeah, never.
There's nothing like watching it.
The actual man. Wow.
Ja, das hätte mich noch von der letzten einverstanden. Nee.
We're saying, oh, we love the lady in the yeah.
How does it sound to you when you're speaking to them?
I think it's going to send us to the circuit.
You have everything flat?
Yes.
Flat?
Yeah, we're 4 times the big story.
And what do you know?
It's building. But like I understand.
Yeah, you have some understanding of the language in general.
Yeah.
Yeah. You also had German in elementary school, and I had it in high school as well.
I tried to learn it on Duolingo, but
Yeah.
it's so hard.
Yeah. I would never learn your Spanish.
No, exactly.
For me, it's the most beautiful language.
It is.
Yeah, I love to listen to it. I could listen to it for all day, every day, but it's so hard to learn.
But it's not when you compare it to English that
No,
doesn't have any rule whatsoever, and you have German which has
English is easy to pronounce in German. It's like
no.
they love to play.
You can just take a word.
No, they have long words with so many letters. Yeah, I don't know how to read that. There's so many letters that I'm like,
We love to like just put words together.
Yeah.
Love it when you some words are really
That one word is the longest word in like ever.
Yeah.
Something like washing machine.
I saw that and picked up. And you have, I never know what is female gender, male gender, word. That like, I don't even know the rules.
Yeah.
We have
I also asked some days ago what the roots are. I don't know.
Yeah, you just know.
Yeah, like-
But then like,
We don't even sometimes know our own articles. So they're like multiple articles for one word in German or something because just people keep using it all.
then, that,
Yeah.
And then we also have like those like I know.
Yeah.
We also have
Mine,
those cases, so
yeah.
like also what is that? Disney.
super hard.
Yeah.
Have you learned the Spanish? It's like the most difficult thing in African language.
Yeah. Yes. Because 7, you have 4.
Yeah, it's like more
Okay, so let's continue. We said that there is, apart from forum internum, so the internal dimension of freedom of thought, conscience, and religion, there is forum externum. And it implies freedom, either alone or in community with others, and in public or private, to manifest one's religion or belief in worship, teaching, practice, and observance. So, as you can see, that manifestation, external expression of one's religion or belief can be either alone or in group with others, in community, and it can be either private or public, and it implies, it encompasses such a manifestation as it is the case with worship, teaching, practice, and observance. So, and these are between some of these terms are more clear and are easier to delineate from the others, and others are overlapping with each other. So the court is not so much in general obsessed with defining something as worship, teaching, observance or practice. Especially practice and observance can be, or then they can also, observance can in some respects overlap with worship. So it is not so much important. These were more exemplary causa, exemplary illustrations of what manifestation can look like. But what is interesting is to see how how it is defined by general commentary of Article 18. So that's there we have some sort of definitions, which is interesting. So worship extends to ritual and ceremonial acts, giving direct expression to belief, as well as various practices. So here you have practices integral to such acts, including the building of places of worship. So its worship is to have ceremonies, yeah. But if you don't have a building where you can have a ceremony, you cannot have a ceremony. So it's an extension as well of that notion. So including the building of places of worship, the use of ritual formulae and objects, the display of symbols, and the observance of holidays and days of rest. So all of that can come under the term of worship. And here I will send you these presentations. You will find different. Manusakis and Others versus Greece was exactly about having a building, possibility to have a building to worship. Metropolitan Church of Bessarabia and others was about secession of one part, of one group of believers from a church, and their wish to establish another church. And Hassan and Chaush versus Bulgaria was about the clash between in the Islamic community, the clash between two leaders who will be considered as the leader of that Islamic community, which of course has a consequence for the worshiping, because that the person who is supreme in conducting the ceremonies, administrating the ceremonies. And then the similar kind of problem was in the Holy Synod of Bulgaria, but now from the Bulgarian side, from the Orthodox Church side. So there are other cases. The Romanian case was about the possibility of members of the church to have their trade union. The Fernandez Martinez was about freedom of expression. So it's various things can come into context with worship. Observance and practice. The observance and practice of religion or belief may include not only ceremonial acts, but also such customs as the observance of dietary regulations, the wearing of distinctive clothing or head coverings, participation in rituals associated with certain stages of life, and the use of a particular language customarily spoken by a group. So that's an interesting case of, for example, sexual mutilation, participation in rituals associated with certain stages of life, genital, so not sexual, but genital mutilation, for example, that you have both with boys and girls in certain traditions. So that is, and then there is a whole list of cases like Shalom Tzedek versus France, which was about the use of animal meat, which was not where the animal was not slaughtered in line with the kosher, in line with religious precepts, for example. So there are religions who attach importance to it. Leyla Shahin versus Turkey was about the use of headscarf in a Turkish university. Kervanji versus France was about the use of headscarf in a French secondary school. Ahmet Arslan and others versus Turkey was about men using gowns which are similar to female dresses, which was in line with the religion of the applicant. SS versus France, that will be the case that I will ask you to take a look at. It's about the prohibition of burqas in France. So I will tell you what exactly to look at in that case. And Aveida and others versus the United Kingdom, it's actually a group of a group of cases related to the use of religious symbols by different employees. Sometimes in the cases of there are some cases of private employees, there were cases of public employees, and they were using religious symbols like chains or headscarves. So that's there is that Veda versus another versus consists actually of 4 cases within one. And then practice and teaching. Practice and teaching. So you see that the Article 18, the writers of the commentary, they put together practice and observance and practice and teaching. The practice and teaching of religion or belief includes acts integral to the conduct by religious groups of their basic affairs, such as the freedom to choose their religious leaders, priests, and teachers, the freedom to establish seminars or religious schools, and the freedom to prepare and distribute religious texts or publications. So basically, to spread one's religion. That is something which is typical for all religions. A missionary role to feel the obligation to convince the other of the need to adhere to their religion or to reconsider changing their religion. Now, what will be important for the next class, and what is anyway important for you, is to understand how this test functions. So the test is related to the conditions under which freedom to manifest one's religion or belief can be limited. So as we said, forum internum cannot be limited, forum externum can be limited. So the freedom of thought and conscience and religion within the internal aspect cannot be limited, but this can be limited. And first of all, it has to be prescribed by law. This is what we call the principle of legality. And within its case law, the court has held that, first of all, why prescribed by law? The principle of legality guarantees certain transparency, publicity, guarantees that prescription, that rule will be discussed, that it will be a result of the debate, an assumption that a law is as it was stated already in the Declaration of Rights of Man and Citizens, so all the way back to the late 18th century. As the Declaration says, La loi expression de la volonté générale. The law is the expression of the general will. So that presupposes that general will has opportunity to express itself, so that there is a debate, there is discussion in the parliament, and that through that discussion, parliamentarians come to the best possible solution to whatever is the object of their decision making. So there is that part that it is considered as something. The law is considered as something rational, expression of rationality, enlightenment. And then it's public. So especially nowadays, everyone can follow the work of Parliament through official channels, or maybe even physically being present, or through the reports, etc., etc. But then the court also took into account that in some countries, human rights got developed also through the case law, like common law countries. And the European Court of Human Rights has considered that the principle of legality doesn't necessarily mean a law or a statute or an act which was adopted by the parliament, but it can also be a consistent case law. When there is a case law, when the courts of the given country and tribunals, when they develop a consistent case law, when they abide by that case law, when they respect it, when they apply it as it is, then it doesn't matter if it is, a law issued by parliament or a case law developed by courts. So that is also considered as if the rule is developed through a case law, then it will be okay. It will be considered as prescribed by law. Or it can also be sometimes infra-legislative acts. It doesn't have to be necessarily a legislation like issued by the parliament. It can be an infra-legislative act, sometimes a decree issued by the government or maybe some other public body. Okay, so this is generally, this is a condition which is relatively easy to satisfy. Countries can relatively easily satisfy because in principle things are regulated by law, but the court also considers that the law has to be clear and it has to be of such a nature, it has to be well formulated, of such a nature to allow the citizens to predict the consequences of their behavior. So it's not just enough to have a law or to have a good case law. That law or case law or infra-legislative document has to be clearly written, and it should allow to anyone to foresee the consequences of, there is this condition of foreseeability. It has to be foreseeable. The consequences of one's behavior have to be foreseeable. And sometimes the court will, so if it finds out that in the given case, there is if the applicant claims that the law is not clear, or that not just the law is not clear, but the case law of the courts is not clear. If the case law is contradictory, not just if it is not clear, if it is clear but it is openly contradictory, in that sense, offering divergent scenarios of possible legitimate legal behavior, the court will find there was a violation of that right. Just because of the principle of legality was not satisfied. Normally, it is easy to satisfy it, but there are some instances where it was found that there was a violation. And also, it may be the case that that the law is clear and it is the action which it prescribes is foreseeable. The terms which are used, but there is no the coherence between what is prescribed, conformity with what is prescribed, and what the official action is. So if the official bodies do not respect what is prescribed, the court will consider that it will from the outright to say there has been a violation of the convention. Okay? So this is the first thing which the court will look at, whether it was prescribed by law. The second thing is what comes at the end in this paragraph, and that is whether there has been a legitimate aim. That if it is that there is a question of public safety, that it was for the purpose of protection of public order, health or morals, or protection of rights and freedoms of others. So this is these are called legitimate aims, and you have to prove that the government, when the case is brought, the government has to prove that that limitation serves a legitimate aim. So there is limitation is for a good cause, for a good reason. Yes, Jan.
Is it public health also, or just health?
Health. It's not.
I have a case
Yeah.
that I want to.
Mhm.
So if there is like a family, which is religion,
Mhm.
and their religion forbids.
Yeah, the transfusion of blood.
Yeah.
Yes.
And they have a child and
Yes.
need
Mhm.
blood. Is it?
Yes, that would be, for example, that would be a case where you, actually it can be even considered a sort of, that would be a case of observance of religion. So the decision of the family not to accept the transfusion of blood could be considered as a sort of observance of or a practice. Like we observe our religion, and so we refuse to accept
That's for the minor child.
No. I'm just framing it. I'm putting it in the conventional language. Yes, it's a way of observing. No, it's a way of observing it. Like it is an observance, but it doesn't mean it cannot be limited. Exactly. It's a very good case for the purpose of protection of health of a minor child. Or we can also put it in the context of protection of the rights and freedoms of others. If it is a question of life, the question of physical integrity, etc., etc. So that is something that
It is a restriction.
it is. Yes. I'm saying we'll come now to the necessary democratic society. It's not over.
Okay.
But that would be a good example, to give, because then comes so you have to put it in one of these categories, and this is I don't think I have ever seen a judgment where the court found that there was no legitimate aim. Although you will see that in this SAS and versus France, the question of legitimate aim is interesting. The way the court saw it and how the court framed it. So that's an interesting. That's an interesting case from that perspective. But in general, you see, this is very broad. We can find easily a way to put it under some category. Now comes necessary democratic society. So necessary democratic society. The term itself is very specific for the European Convention, but it has been taken by some other than constitutional texts, including Serbia. We have it also in Serbian constitution. Neophodno demokratskom društvu. What has been previously developed in the case law of the United States Supreme Court and in general their federal courts is a test which is called clear and present danger. So when you're limiting some right, you have to show that there was a clear, so undisputed danger which was affecting some other right or legitimate aim. Clear and present danger. So it has to be imminent. It cannot be some distant danger. So here, for example, the question of necessary society or the question of transfusion of blood would come into discussion. For example, was it really necessary? The term which the convention uses is necessary democratic society, implying that in democratic society, freedoms and rights should be understood in a very, very broad way. This is a democratic society because we are a democratic society and not a totalitarian society. So we cherish our freedoms and rights, and only when it is necessary. we do limit that. So you have to show that that was in that particular case. So everything else which I said is of general nature. Legality, general, it can apply to you, me, someone else, blah, blah, blah. And legitimate aim, it's easy to square it. But then in that concrete case, whether it was really necessary, because it was needed to protect the rights and freedoms of that person, life or health of that person. So you have to look into the specificities of that case. And then if it was really a matter of life, or if it was a matter of, if it was a question which was relevant if it was a situation in which the health of that person was seriously concerned, and the transfusion was necessary in order to protect the health of that person. But if that was not the case, it was just, for example, if it was not necessary, and you did it, if those health authorities did it, and then they were not sanctioned by the judiciary of that state in the case which was brought. The case may be brought, it depends on the situation. For example, that could be a civil litigation, which families use, for example, a public authority for a health authority for doing it without the permission of the family, and family considers that this was not really a matter of life and death. It is, of course, then up to the whole judicial system to prove whether that was a matter of health and life or death or not. Yeah. So this is where the test. So this is called also the test of proportionality. The terminology which the court uses is pressing. So there are two things. That there is a pressing social need, for example, it was a question of life and death, and that was a proportionate, that you did it just to the extent to which it was needed, and not more than it was. Okay, this is maybe with the blood transfusion. It's difficult for us who are not in the medical field to know what, but then we have expert witnesses who then give to the courts advice as to what was really proportionate, like pressing social need, that it was really needed, but then only to the extent to which it was needed, proportionate. Yeah.
You said conditions are clear and.
In the American case law, it's clear and present danger. This is the test, which is called clear and present danger.
Is it cumulative?
Yes, it's cumulative. It's about. Yeah. And here it's pressing social need, for example, in the context of Dalat versus Switzerland, the question of pressing social need meant to establish whether that was really affecting children. There was pressing social need. And then whether the decision was proportionate, because the teacher was fired. She lost the job. Whether she could have maybe sanctioned in another way, so that even when there was a pressing social need, whether that she could have been sanctioned in another way by some disciplinary measures, allowing her to maybe potentially correct her behavior or not. So this is what is the proportionality will imply when it comes to behavior of the state bodies. Very often it will be concerned with the evaluation of the sanction which was inflicted by the state to an individual who, for example, it used freedom of expression beyond what the freedom of expression implies, like abused freedom of expression. For example, someone who was using hate speech, spreading hate speech. But then you can say, okay, there is a pressing social need because this person within this, you will discuss, for example, where did this person spread hate speech? Was it a professor of law who did it in front of the students? You know, was it someone who was speaking at the television, like in front of a very, very wide audience? Or was it someone who was speaking at Hyde Park Corner, just like, you know, many other people who speak at the Hyde Park Corner? So it's you will take into account a whole sort of issue, like who said that? The higher you are in a social ranking, if you're a public authority especially, it will be considered there is a pressing social need because you are someone who is considered as an important figure. If you, by your social status, you're not really so high, you know, we can say, but you have to take into account what is the weight of the words of that person. But then, not just that, as I said, the question will also be through which media, who was it, through which media. And also, for example, it is one thing to post something on the internet. So hate speech on the internet, of course, it's forbidden, but it's one thing to post it on the internet. Another thing to say it like in a primetime television show, very much watched and viewed, where you as a family, and you have small children, for example, anti-Roma speech, that you watch as a family show something which is a family show, prime time, and then you hear something which is directly affecting you. And then, so here, it's not about going to an internet site, but it comes to your house. But then you can change the television, okay, television channel. As compared to a situation where someone comes and demonstrates in front of your house because you're Roma. Not in front of your house, they come to your village. They occupy your village for a certain period of time, and you cannot even go out of the house. So you're put in a position of what the court calls in Serbian it's called Zarobina Publika, captured audience, where you cannot escape it. Or, for example, me now in a class, I mean, what can you do? Okay, you can maybe, I mean, you're adults, you can leave if you see that something, that things are not really normal. But someone who is, a first-year student, or someone who is in elementary school, or even someone who is in secondary, but even worse, if someone is in elementary school, then they don't really have much choice. So this is pressing. This is how we evaluate pressing social need, and then the question will be whether because you may sue me, and there can be a process against me. It can be a disciplinary process. It can be a criminal process. It can be civil litigation, depending on your choice of instruments. And then I can say, look, and then it's a process which leads to me losing a job. For example, the government. I mean, the judiciary accepts a proposal for that kind of measure where I lose the job. And I can say, come to the Court of Human Rights and say, look, my freedom of expression is violated. Like, I actually didn't do much. I was just presenting students some controversial case, and I wasn't really. My intention was not to hurt anyone. I just wanted to explain a very complicated case, and someone got hurt, without my wish. So we may enter now into discussion after concluding that maybe there was a pressing social need because you're a professor and you really had to take into account all aspects of that complex issue. Yeah, I'll give you the word, especially now after you know that you can sue me. But then the question may be, was that measure proportional, for example? Was there another measure? For example, if I was for something convicted to a prison sentence, and it could have been a pecuniary sentence sanction. And if it is a pecuniary or prison sanction, we can ask ourselves whether the amount or the length are appropriate, proportionate to the legitimate aim which was pursued. So there you have to find the connection. The principle of proportionality implies that you have to apply to find the right measure. If you're limiting the right, you cannot from the right of freedom, you cannot from the outright use I mean, maybe it's a very flagrant case. So you can use the most radical sanction. But you should always try to find a proportionate sanction, not be excessive in sanction. Okay, maybe it's a really very, very bad case, but maybe it's not such a, like imagine if you were a student and you were talking and, you know, I can just do like this or show you by my eyebrows or, you know, or I may come and pull you like they used to pull the hair, you know, or I may start, you know, insulting you. So there are, the sanctions may be different and this may be taken into account. Did you as a professor, did you use a proportionate measure to tell to someone that, you know, speaking in the class is not accepted? There are nice ways and there are ugly ways to say it. Yeah, yeah. Sure, no problem. Yeah.
So, two things. First one, so the proportionality is kind of similar like in a criminal law, right?
Yes, it's you can find, but it applies in all fields of law. Okay. But it's you had unfortunately we don't insist sufficiently in our undergraduate classes, system of education on this principle. It applies to everywhere. It applies to civil litigation as well. Like when you have to decide on the pecuniary, on the compensation, how much you're going to compensate someone for the loss of something, for the material or immaterial loss that someone has suffered. It's that kind of thing.
It reminded me of criminal law.
Yeah. Yeah, it's very much applied in criminal law. It's applied in constitutional law as well when you consider whether adopting law, you know, and adopting measures to restrict certain rights. So.
And when you were talking about freedom of expression and hate speech, I just wanted to say, because I was dealing with that topic for a lot of years before my previous job. So because there is a thin line between hate speech and expression. So we were looking at the hate speech from the perspective that it's not just hate speech, it's like hateful and harmful narratives. Yes. So the harmful, it's like softer, softens that thin line in a sense.
I will give you an example because we will be speaking about freedom of expression on Thursday. So I'll give you some more cases about in order to. But this is the classical. This is what the court does. This is the test which it uses. This is how the court understands this standard of necessary democratic society. That there is a pressing social need. This is the term which the court uses, and that it is proportional. Now you can when it comes to discrimination, it's the harmfulness, of course, can be taken into account, but it doesn't have to be harmful. It can. You don't have to show that it harmed anyone. It is if something is objectively hate speech, or maybe you can say it harms everyone. It doesn't have to harm because the hate speech in the language of the European Court of Human Rights actually implies two things, which in some other jurisdictions are separated. One thing is to use that kind of harmful language, which is intended to mobilize certain population to develop the hatred. Okay. No, I think he muted himself. Right? It wasn't me. So it is to direct individuals or groups towards another individual or group just because of his, hers, or their belonging to certain groups, to having certain identities. So it's what we call the ground of discrimination, personal ground of discrimination. So that is very often the two things are combined into one. This is one thing, to direct someone's hatred towards another person, and at this, or independently or at the same time to instill fear or harm in that other person. So it may be that most often when we do it in public, in like television or through internet, in public gatherings, but not so much in public gatherings. Like on television, like these channels, which are platforms and venues which are open to technically to everyone. So by saying those words, you at the same time instill fear in those individuals, and you direct the others to hurt them, to hate them, to discriminate.
Do you create stereotypes and prejudice?
Yes,
Around
yes, you use them. You create them, or you use them because they're already there, and you actually, yes, you basically you apply them. But technically, it is possible. For example, that I start here. You're not a part of any of those groups, which I'm going to start now. Insulting, but I do it so that because I'm a professor and you're my student, so I think I can. You have it, of course, in situations where when you're in a position of certain power and you have followers. So even though there is no minority present, no one from that group which is actually attacked, no one is directly attacked, but I'm creating that kind of atmosphere in which some of you is going to go and commit what I'm saying should be committed. So these are two different things. Or I can come, as I said, with a group of my friends, and we can, come to the houses of any minority. There are cases, of course, especially of Roma, where you start, chanting songs which they will hurt them, or using symbols that they will hurt them, or just doing it in front of their house, which is going to hurt them because they can, they're going to feel threatened. It's going to instill fear in them. They're going to feel debased, devalued, and finally they will decide to leave. This is the whole point of that kind of orgy. Yeah. You want to add something? Okay, we'll have more. We'll discuss more about freedom of expression and limitations of freedom of expression in the last class. Yeah. Now I invite you to take this judgment, SAS versus France, and you who are online as well. So everyone should take this case, and I don't think I have a case number, but you're going to find very easy. It's a grand chamber. Okay? The grand chamber case. I can't move this as much. Yeah, okay. I have a case. I have a number. You can note it down, and you can 43835/11 of 1st July 2014. And in that case, of course, I can take the photo now. In that case, the facts are relatively simple. So you'll see it's not a complicated case. And I invite you to read these I invite you to read how the court reasoned the legitimate aim and necessary democratic society, those two parts. So you'll see when you take a judgment of the European Court of Human Rights, first you have the facts, and then you have the law, and then you have the reasoning of the court and what is the holding, what the court decided. So you will go to the reasoning part, and you will look at, this is the part that we will study, okay? The facts are relatively easy, as I said, we don't have much problems. Look at how the court dealt with the necessary democratic society and with what the court found as a legitimate aim for that case, in which it decided that wearing burqas in public places in France was not allowed. Okay, and you will see some other things. You will see some other things that the court takes into account when you will see. I mentioned it in the first introductory class. The notion of the margin of appreciation. You know, when the court is not clear how to decide a case, for example, in Bayatyan versus Armenia, for a very long time, as I said, the court considered that conscientious objection was not acceptable because, as I said, serving army was explicitly stated in Article 4 as not that it could not be considered as a case of slavery, type of slavery, or sorry, not slavery but forced labor, and then there was a number of applications. People brought their applications, and the court said, no, look at Article 4, paragraph 2. But after a while, the court said, I see that almost all countries in Europe, except for Armenia and Turkey, have decided to introduce conscientious objection. And so there are so many cases in which serving army is, one can be exempted from, dispensed from serving army on the account of conscientious objection. And then the court said, okay, it is the time to reconsider the conscientious objection. So that will be something that the court will take into account. Well, you have a comparative research. The court has a service which does that kind of comparative research. Like the court has a unit which is called jurisconsult office, and that is a sort of horizontal service. It follows what all the chambers of the court, the cases pending before all of the chambers of the court, and it will try to harmonize it so that there is no there are no discrepancies, so that it is cogent, the case law. So the court will then, this is how court develops its case law, how it is consistent, cogent. And it will, for these purposes, it will send a request to all the lawyers in the court, in the registry. They come from all the member states, so they know the case law of the member states, and the court will ask them to write a report. And then the lawyers will say, okay, always you find someone from some country to write a report about that's a part of what will become a comparative report on the state of that issue in the given country. So that will be, this is what the court does, you see. This is the standard, this is the method which it applies when it comes to examination of a legislative measure, whether legislative measure is appropriate or not. So the more the countries are unified in a harmonious, then the court will limit the margin of appreciation of a state. So the court will say, you have a very limited margin of appreciation. It's in a very, very rare, you have to really prove it. Like, you have to show very convincing arguments that you deserve to be exempted from something which has become a rule almost everywhere. But if it is an issue of debate, then the court will initiate debate in many countries, such as many issues of bioethics, like euthanasia. The court will then say, okay, there is no consensus among states, and I cannot impose. Like, I'm just a sort of international court. What is my power to tell you what you should do? Like, your legislator and your judiciary, they know better. There is that kind of presumption. Okay. Good. Well, then take a look at it. If you have any questions about, read it tomorrow. If you have any questions about it, any dilemmas about, I want you to look into these two issues: tested democratic society and legitimate aim. And,
Take a picture of that one.
yeah, sure. Of this one. Yeah, I'll send it. Yeah. This is you'll find in the judgment the standards, the test. Yes. So you will think about that judgment and consider whether the court took into account the gender equality perspective appropriately, and whether a full recognition of the gender equality could have led, if you think that the court didn't take sufficiently, maybe you'll say that it did, because it did consider it from a gender equality perspective. You can then reconsider whether, if you think that it was not sufficiently taken into account, whether that judgment could have been drafted differently. And with what arguments. Okay? Good. Well then, I hope it is also clear for those who are online.
It's clear, Professor. Thank you.
Okay.
Everything was clear. Thank you.
Okay, thank you, Alexandra. Thank you, Una. Thank you, Abdi and Saifu. And I wish you a pleasant evening. See you after tomorrow. Bye-bye.
See you tomorrow, Professor. Goodbye.
Bye.
After tomorrow, yes. Bye-bye.